Good morning. I'm Gary DeWaal, and this is Bridging the Week for July 16th to 20th, and today is July 23rd, 2018. A federal court in Brooklyn, New York, rejected a defendant's request to reconsider an early denial of his motion to dismiss an enforcement action against him for fraud by the Commodity Futures Trading Commission in connection with his alleged provision of virtual currency trading advice and for the discretionary trading of virtual currencies. The defendant had claimed that a subsequent decision in a California federal court related to a metals dealer supported the proposition that the CFTC had no authority to bring the anti-fraud case against him in connection with transactions involving commodities that are not derivatives unless the CFTC alleges a fraud-based market manipulation has occurred. Separately, the Securities and Exchange Commission sanctioned a broker-dealer for inadvertently deleting audio records of telephone conversations of 8 salespersons subject to an SEC request, as well as for not properly documenting and maintaining records of some employees' gifts and expenses. Regrettably, Bridging the Week will take another 1-week hiatus so I can attend the 65th wedding anniversary of my Uncle Bill and Aunt Mary in Kelseyville, California next weekend. So I get through my work this week and pack. Let's get started. A federal court in Brooklyn, New York denied the request of Patrick McDonald to reconsider its March 2018 rejection of his motion to dismiss a CFTC enforcement action on the ground that the agency has no authority to exercise enforcement authority over an alleged fraud involving cryptocurrencies absent a claim of fraud-based market manipulation. Earlier this year, the CFTC sued Cabbage Tech Corp., a New York corporation, and Mr. McDonald, its owner and controller, for unlawfully soliciting customers to send money and virtual currencies for virtual currency trading advice and for the discretionary trading of virtual currencies by Mr. McDonald. However, alleged the CFTC, the defendants did not provide the promised services and misappropriated their customers' funds. In response, Mr. McDonald filed a motion to dismiss. The Brooklyn Federal Court denied Mr. McDonald's motion, holding that virtual currencies are commodities under applicable law and that the CFTC has standing to sue persons for fraud in connection with spot sales of virtual currencies, even where such sales do not involve the sale of derivatives contracts. In his motion for reconsideration, Mr. McDonald asked the court to reconsider its earlier decision based on the outcome of a May 1, 2018 federal court decision in California involving Monex Deposit Company and other defendants. There, the court held that the CFTC cannot use the prohibition against persons engaging in any manipulative or deceptive device or contrivance in connection with the sale of any commodity in interstate commerce, enacted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act to prosecute acts of purported fraud, except in instances of fraud-based market manipulation. In ruling against Mr. McDonald, in response to his request for reconsideration, the Brooklyn Federal Court noted that it, quote, fully considered Monex and reaches a different conclusion, end of quote. The court said that, in its view, the relevant statute supported the CFTC standing to bring its enforcement action. By the way, the Monex decision was recently appealed by the CFTC to a federal appellate court in California. BGC Financial LP agreed to pay a fine of $1.25 million to the Securities and Exchange Commission for inadvertently deleting audio files containing communications of 8 registered representatives requested by the Commission, and for not accurately documenting and maintaining records of various employees' gifts and expenses. According to the SEC, in March 2014, SEC staff issued 2 requests for communications of the 8 salespersons, including recorded telephone conversations. Previously, however, in 2013, BGC had amended its record retention policies to provide that digital audio recordings should only be maintained for 1 year. In response, BGC promptly began to delete existing dated audio recordings. However, no recordings of the 8 salespersons were eliminated because of a prior litigation hold. However, when the prior litigation hold expired in May 2014, audio recordings responsive to the SEC's March 2014 request were inadvertently deleted because relevant BGC audio technicians had not been advised of the SEC's new request, said the SEC. BGC discovered the situation shortly after the deletion and self-reported the deletion to SEC staff. Separately, the SEC claimed that from 2014 to 2016, BGC did not record properly gifts and expenses of certain high-performing registered representatives, and as a result, did not maintain accurate books and records. Among other things, the SEC said that the firm did not reflect season tickets for an unnamed New York sports team that were used personally by the salesperson as compensation, and sometimes it reflected expenditures for 2 brokers as business expenses when the relevant registered representatives failed to provide expense report with the names and customers of attending customers or identified customers that were not present. Additionally, sometimes, claimed the SEC, BGC reimbursed registered representatives for expenses when in fact the salespersons were not present for the relevant activity. As a result, such expenditures should have been reflected as gifts. Separately, BGC, on its own, determined that an expense administrator used a corporate credit card in another employee's name to likely misappropriate $1.3 million for personal expenses. As a result of these episodes, the SEC said that BGC failed to keep accurate books and records of its expenses. I have pointed out this numerous times. To minimize the likelihood of regulatory issues, registered entities need to think holistically. Important information that's not shared with one part of an organization with another often leads to regulatory problems. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week in 2 weeks, ciao.